Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything,
Right, exactly.
I'm
Probable
going,
cause or anything.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me?
Welcome in, because from the very first seconds, this courtroom is already charged with tension. What you're witnessing is not just another routine hearing. This is a defendant attempting to represent himself, immediately clashing with the authority and structure of the courtroom. Judge Simpson, who runs a firm and orderly courtroom, quickly senses that things are about to spiral. When someone chooses self-representation, it's their constitutional right, but it comes with enormous risk. No lawyer buffering mistakes, no professional translating procedure. One emotional misstep, and suddenly the judge's patience is tested. And right here, before we even fully understand the case, the defendant interrupts and challenges the ruling, triggering a warning that sets the tone for everything to come. Yeah, and listen carefully to what the judge says. If another outburst happens, jail becomes a real possibility. That's not drama, that's courtroom reality. Judges demand order because decisions affect freedom itself. So here's the question to you watching right now. If you felt misunderstood in court, would you stay calm? Or would frustration get the better of you too? Because as we're about to see, emotions in court rarely end well for the person already on the defensive. And this hearing, it's only the beginning of much bigger problems about to surface.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes the set of bond violation hearing. April 16th, 2024 at 2 p.m. At 2 p.m.
This moment might sound procedural, but it's actually a massive turning point. A bond violation hearing means the court believes the defendant may have broken the rules required to stay out of jail while awaiting trial. Bond isn't freedom without limits, it's conditional freedom. And think about what just happened. Instead of focusing on defending himself, the defendant starts negotiating time served, hoping those days already spent in custody might soften future conditions. But courts don't operate on sympathy, they operate on compliance. The issue isn't how long you've been waiting, it's whether you followed the rules while you were free. Judge Simpson makes it clear, all issues will be addressed when he appears. But the subtext here is important. Judges keep detailed mental notes about behavior. Every interruption, every misunderstanding, every frustration adds context to future decisions. Here's something to think about. Do you believe courts should show flexibility when someone struggles with bond conditions? Or should rules be enforced strictly every time? Because from here forward, every detail of this defendant's behavior is going under the microscope.
Is there anything further, sir?
With the bond, yeah, that will all be discussed as part of the tender condition. Because this time, months, I think, hoping this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Maybe, yeah, I can't afford cash bonds or something, just right, be around on maybe time that I've got it, you know.
I don't know what you're asking me.
if the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you. Court does call the case of the people state of Michigan versus Cody Lee Jolly. Your name, sir?
Cody Lee Jolly.
Okay. This is a bond violation hearing. Please go ahead.
Before we begin, I do have a copy of the police report outlining the violations, a copy of the complaint of violation release, and 3 photographs all to give to the defendant so that he could review them before. Like, there's a paper.
All right.
Thank you.
Mr. Jolly, you had an opportunity to look through all of that?
Yeah.
All right. So let me ask you this. Do you still wish to continue with the hearing, or do you wish to admit to a violation of your conditional bond? As the court understands that there would be 2 potential violations: the violation of the substance abuse or substance provision of your bond. The other would be not to commit any crime, as there is the crime of trespassing, which has occurred or appears to have occurred.
Now, the real legal crossroads appears. The judge presents 2 alleged violations: substance-related issues and trespassing. And this is where legal nuance matters. Many people assume you must be criminally charged for a violation to count, but bond conditions don't work that way. A judge only needs to believe that prohibited behavior occurred, not necessarily that formal charges were filed. So when the defendant asks whether trespassing counts if he wasn't charged, he's thinking criminal court rules apply here. But bond court operates on conditions, not just charges. This exchange is crucial because admissions here carry immediate consequences. Once he acknowledges substance issues and being somewhere he was told not to be, the legal leverage shifts strongly back to the court. And let's pause here. If you were in his shoes, would you fight every point hoping to win technical arguments, or admit mistakes hoping the judge shows leniency? Because sometimes honesty helps, and sometimes it confirms exactly what the court feared. The tension now is no longer about misunderstanding rules. It's about whether the court can trust him outside jail at all.
Well, question, I guess, then, but just if I wasn't charged with trespass and stuff, right? Because I've not been.
I understand that.
Okay, so then would that technically come into play as legally? As
The condition of the bond is that you not commit any crime.
Right.
Trespassing can be crime. Doesn't matter whether it's charged.
Okay.
It won't for the court's consideration.
Okay. Sure. Okay.
So what do you wish to do?
I mean, I don't, I guess I mean, I admit that there's probably weed on me that was still there. I didn't know that much weed on me. That was still there, and yeah, about the trespass, I don't know how it comes in.
Well, you had been read trespass before, correct? I mean, you don't have, pardon?
I never remember that.
So if the court understands it, correct me if I'm wrong, I mean, you can certainly look at it, that you had been read trespass from University of Michigan properties before?
Oh, I think due to this, I guess due to this ongoing case, because I have a
Right, but-
case into to you,
Hold on.
They said that it's just this case. I've already, I'm.
Right, but Mr. Jolly, my point is that you've been read trespass from from University of Michigan, right?
Yeah, but I'm in court paperwork with them. I've argued it.
Okay, all right, then let's,
Pretty cool.
all right, you want to go around and round about that, I won't
It's okay.
necessarily go round and round about it. I mean, you admit to violating the substance provisions. You do admit to that.
Correct, and I was at the library.
All right. Pardon?
I was at the library.
Right.
Correct.
And would you admit that you shouldn't have been on the library property?
Yes, yeah.
Because you had been trespassed before, right?
From the, right, yeah, all the stuff, right.
Right? Okay. All right. So you're admitting to those violations.
Right.
I expect everybody to come down. All right. I will accept those admissions to that. Now, you wanted to argue your bond, sir, given the violations?
Yeah. My thing was just that, you know, that still going through the court process, trying to get the trial. Already done 2 months on this tether. It's done over 2 weeks, doing only 15 days so far in jail, and I haven't been to trial yet. So my hope was that with all that time served and not being convicted yet, that I could just go back and to being a regular citizen, treated fairly, and await trial.
All right.
This is the emotional heart of the hearing. The defendant appeals to fairness, arguing he hasn't been convicted yet and wants to live normally while waiting for trial. And legally, he's correct about one thing. He is presumed innocent. But bond decisions aren't about guilt or innocence. They're about risk and compliance. Judges ask, will this person follow rules if released? And from the judge's perspective, violations already happened once. Notice how Judge Simpson keeps redirecting the conversation. This isn't punishment. It's about conditions that were agreed upon and then broken. The court feels its trust was already tested. And emotionally, you can sense frustration building. The defendant feels trapped in a system moving slowly, while the judge sees someone who already ignored court instructions. So let me ask you, should courts prioritize giving people second chances before trial or protect public safety first when someone breaks release conditions? Because the next moments will show how the judge weighs that balance.
And I'll certainly hear from people, but here's the court's concern with releasing you. You originally were released on this case, right? And then shortly after being released, you're in violation of the conditions of your release. Right?
I don't know that. This has been 2 months.
Well, you just admitted to violation. Well, but you just admitted to violations, right? Right?
Right.
Okay. So what tells me that if I were to release you, that there wouldn't be other violations of your condition?
That's kind of what I'm asking, is that if you could remove the conditions, because I haven't still going through the court process. My thing is, I don't have money to.
No, Mr. Jolly, you don't understand how this works. You were released, okay, with certain conditions regarding your release, right? Right?
Right.
Okay. So you were free to do what you needed to do as long as you abided by those conditions, right? That's where you were.
Right.
Then at some point, you violated those conditions.
Right. It's been 2 months.
Okay, but it doesn't matter. You violated the conditions, right? Okay. Now, Mr. Jolly, here's the problem. If you think for one moment that even if I were considering your release, that I would release you without any conditions, that's not going to happen.
This is where legal reality hits hard. The defendant tries to argue for release without strict conditions, possibly out of frustration or misunderstanding. But judges almost never release someone accused of serious offenses without safeguards. Judge Simpson's tone changes here. Less discussion, more correction. He's making clear that release is conditional privilege, not automatic freedom. And the defendant's repeated acknowledgments, right, show he's listening, but maybe still not fully grasping how deeply the violation affects trust. This exchange also shows something viewers often miss. Judges aren't arguing emotionally, they're documenting logic. Every answer becomes part of the record explaining future decisions. Here's a thought for you watching. Do you think defendants representing themselves fully understand how legal decisions stack against them? Or do emotions often cloud judgment in moments where precision matters most? Because from here, the conversation shifts away from debate and into evidence that may seal his fate today.
I'm just trying to.
So then the question becomes, Mr. Jolly, when you say you want me to release you, how can you assure the court that you will abide by the conditions that have been set?
Just the fact that I'm a law-abiding citizen, besides the fact that I'm guilty of this, I have no proof that I haven't been convicted guilty of this, proof that I did. Besides this ongoing I'm a law-abiding citizen, so I just ask for being considered innocent.
Sir, you are considered innocent until proven guilty, but the court also has the ability to set your bond and give conditions. All right. The court initially did that, and you violated those conditions.
Yeah, no, I understand what you're here. I think a lot. I do my best when I get out. That's when I get out. I'm a law-abiding citizen. I do.
Here's what I'm going to do. Was there anything from the people?
A couple of things. So what I didn't realize, and I apologize, but I wasn't reading the report properly the last time we were here. It's 2 events that he's back at the library. So when I was speaking with the office beforehand, they made that abundantly clear to me.
That there were 2 times that he was, yes.
Yeah, at 2 separate libraries. So I'm not really sure what's going on.
What do you mean? What's going on? Oh, are the things out there again? It was balloons? So there's this filter thing, and we're trying to figure out where it comes from. We'll sort that out. But the balloons are pretty, I bet. They were. Okay.
So it's 2 April 3rd at 5:55 p.m. He was there. He was looking at pornography. According to the police report, he was looking at pornography at a public computer that he was suspected of masturbating. I asked the officer who's here to give me additional details about that. And I believe the information I got was that the witnesses believed he was masturbating, perhaps that his pants were in a certain position, that he was rubbing his genitalia underneath his clothes, which is similar to the events that April 5th, in the sense that when the police get there, he's not actually exposed, but certainly conducting himself in a way where he's got his chest exposed, his outer layer of pants pulled down.
And now the courtroom atmosphere changes completely. What started as technical bond arguments suddenly becomes far more serious. The prosecutor outlines allegations of inappropriate conduct in a public library, tied to an already serious case involving sexual misconduct charges. This matters because bond decisions hinge on patterns of behavior. When prosecutors present incidents suggesting repeated misconduct, especially in public spaces, judges start thinking about community safety. Also notice the prosecution strategy. They don't rely on one event. They reference history across multiple states, painting a broader picture of behavior over time. That narrative makes release harder to justify. And remember, these are allegations, not convictions, but bond hearings operate on risk assessment, not final guilt. Let's pause here. If someone repeatedly appears in trouble across different states, do you think courts should treat each case separately, or consider the bigger pattern? Because for Judge Simpson, this pattern now weighs heavily in the decision about what happens next.
and this is a CSC case, so it's like, well, we take that behavior and then we layer it on with the fact that he's out on bond for assaulting nurses at the U of M hospital, and he's now charged with CSC for his sexual assaults on them. But in response to the I'm a law-abiding citizen, I mean, I'm looking at his criminal history from Florida, I'm looking at his criminal history from North Carolina, I'm looking at his criminal history from Michigan. The majority of what I'm seeing are misdemeanors, but I do have carrying a concealed weapon from North Carolina. There are larceny offenses from North Carolina. And
No.
well, there are. I'm not looking at them right now.
Sir, hold on.
In Florida, there is a charge of battery, touch or strike. It was a misdemeanor assault, is what I would probably call it here. Resisting obstructing the police, which is clearly listed as a felony. In Michigan, which seems to be his most recent history, it appears that substance abuse is an issue. In 2010, he was convicted of operating while intoxicated. In 2011, there's a minor in possession that is still listed as a bench warrant. I don't know what that's about, out of the 90th District Court. 2016, retail fraud conviction. 2017, a conviction for use of controlled substance. That looks like it was pled down from a possession of dangerous drugs. Is what it is initially entered at. But all to say that this is not somebody who has no criminal history. This person's criminal history spans across at least 3 jurisdictions. So, Your Honor, at this point, I'm asking you to not release him. I do also have a question, though, however, about the tether.
Yes.
What type of tether? Like, so I don't have notes from his, the person that arranged him did not put notes in his file. And when I look it up in JIS, I just see that it was tether.
It is not a. It's not a GPS tether. He's simply on a scram.
Oh, thanks, Your Honor.
All right. Anything else you want to say? At this juncture, I'm going to continue the defendants given the circumstances of this case.
At this point, the outcome feels almost inevitable. Judge Simpson reviews everything: violations, allegations, history, and courtroom behavior. And the key phrase arrives: detention continues. Bond remains revoked. This means the defendant stays in custody while the case proceeds. And from a legal standpoint, the judge is signaling that previous release conditions failed to prevent further issues. Notice the professionalism here. Despite emotional arguments and interruptions earlier, the judge calmly explains the decision and sets the next procedural step: the preliminary examination. Courts move methodically, even when outcomes feel dramatic to those involved. Here's the engagement question. Do you think detention before trial should happen more often when bond violations occur? Or should courts keep giving opportunities for compliance? Because decisions like this balance fairness, risk, and public safety, and opinions often differ strongly. And now, with bond revoked, everything hinges on what comes out in the next stage of this case.
I will. The bond violation has been found, and the defendant's bond will continue as revoked. You were set for, I will review that again, but you're set for preliminary examination in this matter this upcoming Tuesday, the 23rd, so a week from today. Pardon?
Do my bond on that day.
I will look at it after I hear testimony in the case. But at this point, your bond will continue as revoked. Thank you.
Thank you.
Welcome in, because from the very first seconds, this courtroom is already charged with tension. What you're witnessing is not just another routine hearing. This is a defendant attempting to represent himself, immediately clashing with the authority and structure of the courtroom. Judge Simpson, who runs a firm and orderly courtroom, quickly senses that things are about to spiral. When someone chooses self-representation, it's their constitutional right, but it comes with enormous risk. No lawyer buffering mistakes, no professional translating procedure. One emotional misstep, and suddenly the judge's patience is tested. And right here, before we even fully understand the case, the defendant interrupts and challenges the ruling, triggering a warning that sets the tone for everything to come. Yeah, and listen carefully to what the judge says. If another outburst happens, jail becomes a real possibility. That's not drama, that's courtroom reality. Judges demand order because decisions affect freedom itself. So here's the question to you watching right now. If you felt misunderstood in court, would you stay calm? Or would frustration get the better of you too? Because as we're about to see, emotions in court rarely end well for the person already on the defensive. And this hearing, it's only the beginning of much bigger problems about to surface.